Well, good afternoon, everyone. Welcome to the City of Madeira Beach Variance and Special Exception Special Magistrate Hearing. My name is Bart Valdez, and I am the appointed Special Magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. And also, if you are here for code enforcement matters or variances, you are in the correct place. The first thing we're going to do is a special exception, then the variances, and then the code enforcement. At this time, I have read and reviewed the applications with all attachments, any written submissions by anyone having an interest, any timely submitted written objections, and the materials provided by the city staff. In all cases, the hearing will be conducted in the following order. The city will present its case and staff report. The applicant may ask questions of the city's representative. The applicant will present his or her case supported by witnesses and evidence, and the city may cross-examine each witness. We will then take public comment. Public participation will then be closed. I will deliberate and then make a decision to grant or deny the request in the application. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced to writing, and the applicant will be provided with a copy by mail. Additionally, you are advised that I do not have the authority to grant you a building permit. You must still obtain a building permit for any work you intend to do on your property. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a few minutes, the city attorney will administer the oath and swear in any witnesses. So what that means is anyone who's in the sitting here today that wants to talk to me is going to need to be sworn in just a couple moments. And of course, this includes any members of the public who are directly affected by the application and may wish to provide comment. Now, the first matter on the agenda today is SE 2025-01 for the Barefoot Beach Club. A couple of the interested parties have lawyers. I think the applicant's lawyer is here also. Ms. Edwards has a lawyer. And so I just want to go over a couple things. The first thing we're going to have to deal with is a motion to continue. That means to postpone this to another month. Again, that's a motion that's been filed by a resident, and then also understand the applicant's lawyer may also be seeking that. I just want to say, if the hearing goes forward today, then it will be a quasi-judicial hearing, and it will begin with a statement by the city attorney that will include a summary of the application, the standards to be applied to the evidence, the burden of proof, and the identity of all parties in the order of their presentations. The next is the first party to present evidence to the board shall be the applicant, so that would be Barefoot Beach Club. The applicant shall make a presentation to include all evidence relating to the applicable standards for review of the application. The next party to present evidence to the board shall be the city, and the city shall provide analysis of the application, which includes a consistency determination with regard to the city comprehensive plan and a determination of compliance with the procedural requirements of law. And then other parties shall follow the city in order of their filed notices. And Mr. Trask, the city attorney, has a chart that shows everyone who has gone ahead and filed something. So, Mr. Trask, I want to start with the motion to continue. I understand the lawyer for the applicant's here. Come on forward, sir. And can you give me your name, please?
Yes, Your Honor. Brian Ungst, McFarlane, Ferguson, McMullen, 625 Court Street, Clearwater, here on behalf of the applicant. And we are also consenting to a continuance. I believe the next hearing before Your Honor would be May 26th, according to Mr. Trask.
All right. And Mr. Trask, I've noticed that forwarded to me today was, and I'll make sure I'm getting this correct, Jane Graham, an attorney for Cynthia Edwards, who filed an objection to the application. Apparently, she filed an email that I'm construing as a motion to continue, says that she is ill, unable to attend today, and her client is unable to attend. So I'll treat that as a motion to continue. She asked for a date in June. I'm willing to move this to the next date in May, but what's the city's position on this, Mr. Trask?
City has no objection to the continuance based upon the applicant's request that it be continued.
All right, and will it be continued to the May 28th date?
So we'd like it to be scheduled for the next date, May 26th, I think is on the calendar. Andrew, can you confirm that? May 26th?
Holiday, I thought it was going to be on a Tuesday, but I know Holden emailed, yeah,
Okay, hang on just a second.
it's supposed to be because of
Yeah, it looks like the 26th is Memorial Day.
yeah, it was,
Oh, we don't want to do it on that day then.
yeah. I know Holden emailed about the 27th. Which is a
Yeah, I've got a note here on the calendar too. Tuesday, the 27th is a question mark.
Next available, whenever y'all have it scheduled, is fine with us.
Yeah, I mean, I will certainly be here. I'm available, so we can do it on, and we would do it at noon?
Yes, we would need to do them at noon.
Okay. All right, based upon the applicant's motion to continue as well as one of the aggrieved parties' motion to continue, I'm going to go ahead and grant that. So anyone here who's for the first one, I'm sorry to make you do this, but you guys are going to have to come back on May 26th at noon.
27th.
27th, May 27th at noon. And so you may receive notice, but I'm just putting everybody on notice here that will be here May 27th at noon. So thank you for coming. If you're here for that special exception, you don't need to stick around any longer, so you're free to go.
will they need to,
I'll give the room a moment to clear out before we move on to the next one.
will they need to do another affected party form?
No. If they have published or provided a notice of intent to be an affected party, they do not need to do it again.
Okay, for this specific public hearing. Okay. Thank you for clarifying that. I just wanted to make sure the public was aware of that.
Good point.
Yeah, I just sometimes. Next time if we had to. Sorry.
I still need to get everyone sworn in too. I need to swear in everyone.
Okay, thank you. All right, so I assume everybody who's left is here for the variance or code enforcement. The first thing we need to do is everybody needs to be sworn in. If anybody wants to say anything to me today, then you need to stand and be sworn in. So, Mr. Trask, can you go ahead and swear everybody in, please?
Thank you. Everybody raise your right hand if you're going to speak today. You swear the testimony you're about to give today is going to be the truth, the whole truth, and nothing but the truth? Okay, thank you.
Okay, the next matter on the agenda is VAR 2025-03. You guys good down there? Okay. For the property located at 422 137th Avenue Circle. Is the city ready to proceed?
We are.
All right, go ahead, Mr. Trask.
First of all, I want to present to you two support letters that the city has received so that you have those. They're from two individuals. I can't figure out their names, so I'm going to go ahead and pass those down to you. Okay, the city is going to go ahead and have Mr. Morris present. So, Mr. Morris, if you could please tell us your occupation and your job responsibilities here at the city of Madeira Beach.
Good afternoon. My name is Andrew Morris. I'm the long-range planner at the city of Madeira Beach. Usually I work on things related to planning like zoning ordinances, comprehensive plan updates, but also I do variances related to variances for land development regulations like this one today.
Are you familiar then with the application for the property address of 422 137th Avenue Circle here in Madeira Beach?
Yes, sir.
Okay. Did you receive an application on behalf of the property owner for a variance?
Yes, sir.
Did you review that application and prepare a staff report and recommendation?
Yes, sir.
Okay. Could you please go ahead and present that staff report and recommendation?
So here's the variance app, VAR 2025-03. It's for property addresses 422 137th Avenue Circle, Madeira Beach, Florida. The request from the applicant is to reduce the front setback from 20 feet to 12 feet, reduce the rear setback from 25 feet to 15 feet, and reduce the side setback on the east side of the structure from 5 feet to 4 feet. The specific code provision this variance is for the section 110-206 setback requirements. And currently in the code, the following minimum setback shall apply in the R2 low-density multifamily residential district. The front yard is 20 feet, the rear yard is 25 feet, and for the side yard, a single family lots less than 50 feet wide may reduce the total side setback to 10 feet with a minimum of 5 feet on either side. So with the background, the variance request for the property at 422 137th Avenue Circle is to reduce the front yard setback, side yard setbacks, and rear yard setback to allow for the construction of a new single-family home on a substandard and a regularly shaped lot. The existing single-family structure on the property was substantially damaged by Hurricane Helene. The property owner can rebuild within the same footprint by right, but the existing home has a side yard setback that is less than 1 foot from the property line. The proposed new single-family structure will meet all current FEMA and Florida building code requirements. The proposed side yard setbacks would be closer to being conforming than the existing side yard setbacks. Located below is a summary table of the existing setbacks and the proposed setback variances. So it shows what is usually required and what the applicant is asking for a variance on. The next part is the section 2-507, variances, criteria, and analysis. Special conditions and circumstances exist which are peculiar to the land, building, or other structures for which the variance is sought and which do not apply generally to lands, building, or other structures in the same district. Special conditions to be considered shall include, but are not limited to, the following circumstances, which are the, I have listed all of them below. With this application, though, the ones that are relevant are A, which is the substandard or irregularly shaped lot. If this site involves the utilization of an existing lot that has unique physical circumstances or conditions, including irregularity of shape, narrowness, and shallowness, or the size of the lot is less than the minimum required in the district regulations. So lot 30, which is the lot that this address is at, is a substandard and irregularly shaped lot. The lot does not meet the minimum site area requirements for a single-family home, which is 4,000 square feet. The lot depth is less than the minimum required, which is 80 feet. The lot width at the front of the lot is less than the minimum required for a single-family home at 40 feet. The next one it meets is the residential neighborhood character, and that is if the proposed project promotes the established historic or traditional development pattern of a block face, including setbacks, building height, and other dimensional requirements. The proposed variance maintains the existing front yard setback of 12 feet, which is similar to nearby properties. The proposed rear yard setback of 15 feet matches the rear yard setback of a neighboring property. The proposed variance supports the traditional development pattern of a block face for the neighborhood. And the last one is E, which is architectural and/or engineering considerations. If the proposed project utilizes architectural and/or engineering features that would render the project more disaster resistant. And the existing home had habitable space at grade that flooded during Hurricane Helene. The new single-family home would be more disaster resistant since the home would be built to current floodplain and Florida building code requirements, which would mean it's elevated. It doesn't have habitable space at grade. It would be high up off the ground. The next part of the criteria is special conditions, circumstances that do not result from the actions of the applicant, and self-created hardship shall not justify a variance. With staff findings, the plat for Lot 30 was approved in 1941 before the current Madeira Beach land development regulations were adopted. The existing home was built in 1950, which predates the design criteria requirements for a single-family home in the R2 zoning district. Both the lot and the home are considered legally non-conforming. The applicant did not make a self-created hardship since the house and lot predate the current zoning requirements. The next one is the granting the variance will not confer on the applicant any special privilege that is denied to other land, buildings, or structures in the same zoning district. Many of the lots located in the R2 zoning district along 137th Avenue Circle are non-conforming and have older structures that are at grade. All single-family homeowners in the R2 zoning district have the right to rebuild within their existing footprint, but many of the at-grade structures have setbacks that are significantly less than what would be conforming. If other neighboring property owners were to rebuild, they would need to apply for similar variances to reduce the nonconformity of the setbacks. The next one is if literal interpretation would deprive the applicant of the rights commonly enjoyed by other properties in the same zoning district under the terms of the land development regulations subpart B of this code or section 14-205 of the Code of Ordinances and would work unnecessary and undue hardship on the applicant. Staff findings, the applicant would not be able to build a new home within the R2 zoning district setback since the lot is substandard. Relying on rebuilding a home within this existing footprint would create a home with minimal side setbacks. The proposed variance would have side setbacks that would be closer to conforming, reducing the impact of the home on neighboring properties. The proposed variance fits within the intent of the R2 zoning district to supporting a mix of lower density single family and multifamily dwellings. The next one is the variance granted is a minimum variance that will make possible reasonable use of the land. Using the existing footprint when rebuilding the home would have led to a house with a side setback far too close to the neighboring properties. The proposed variance allows for reasonable use of the land and does not go beyond the minimum variance necessary. The granting of the variance will be in harmony with the general intent and purpose of the city land development regulations or the Code of Ordinances when it relates to section 14-205, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. The proposed variance is in harmony with the general intent and purpose of the city land development regulations. The R2 zoning district is a residential district that does allow for single-family homes on smaller size lots. The new home would not be injurious to the area involved or otherwise detrimental to the public welfare. Next one is under staff recommendations. City staff recommends approval of variance 2025-03. And the applicant also doesn't have any fines or anything on the property. But yeah, the city staff recommends the approval of variance 2025-03. And attached to this are the application, the applicant's answers, and the support materials where he included a very nice survey that showed the existing structure and what's being proposed and how it is a big improvement because the current one has very close side setbacks because one of them is even less than a foot, which is really close. I also printed out copies of the letters of neighboring properties that are in support of this variance. And then I also attached the public notice mailing and posting where we had to do that 300-foot mailing to property owners around the 300-foot radius. We did not receive any effective party forms for this variance within that the time allowed.
Mr. Morse, did the city receive any letters in opposition?
We did not.
Okay. If you could turn to page 72 of the packet, I have a couple of questions for you on page 72.
Page 72? Okay, sounds good.
So, are you there?
Yep.
Okay. Can you explain then what this diagram, site plan really is so that we're all knowing where the current house sits, where the proposed house will sit, and how it affects the setback variance application?
So the line that is dashed is the existing building, and the solid line in black is what's being proposed. So as you can see, the current building goes really far into the side setback. And because of that, there on one of the sides of it is less than a foot, and then even at the further up at the other corner, it's like 1.7 feet. It also shows how the proposed rear setback would match the neighboring houses, and the existing front setback would be maintained. So the reason why we support this is it would help get them closer to conforming, because the lot is a irregularly shaped lot. So this was the closest we were able to get them to at least get the side setbacks near conforming to reduce the impact of the new house on the neighboring properties.
All right, thank you. I don't have any other questions of Mr. Morris. I would tender into evidence pages 58 through 90 of the packet. Ask that it be received into evidence.
All right, I'll go ahead and receive into evidence as exhibit number 1, the agenda items page 58 through page
90.
And also, I have reviewed, there are variance request support letters from what appears to be the neighbors on both sides of the subject property, as well as, looks like maybe a neighbor on the same street as well, all in support of the variance. So that'll be exhibit number 2. All right, is the applicant here, Mr. Mazzillo? All right. Come on forward, sir. You've heard the city has recommended approval of your variance. However, you have the right to cross-examine Mr. Morris and ask him any questions based upon his testimony that he provided. I'm going to give you a chance in just a minute to tell me anything you want to tell me, but do you have any questions for Mr. Morris?
No, I think you did a very good job.
Okay, great. Thank you, sir. Any other witnesses?
No other witnesses on this case.
All right. Sir, this is your opportunity to tell me anything you'd like to tell me about your variance request.
I've lived in a home since 1989, and it's planning on being my home when I retire, to keep it. But me and my family are looking forward to moving back in. The average width will be 5 feet, which is shown in the middle of the drawing, due to the pie-shaped lot. And we're trying to keep it as close as we can. We're looking, we're proposing a modular building which has standard widths of 15 feet, and there's 2 modules that go together, makes the 30. But that's it.
All right, Mr. Trask, any questions for the applicant?
No, sir.
All right. Are there any members of the public who are directly affected by this variance who want to come forward and provide public comment? All right, seeing none, we'll close public comment. Anything else on behalf of the city?
No, sir.
All right, I will go ahead and grant the variance in VAR 2025-03. All right, let's move on to the next one on the agenda, which is case number VAR 2025-04, and that's for the property located at 14830 North Bayshore Drive. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
The city would call Joseph Petraglia. Joe, if you could state what your occupation is and your job responsibilities here at the city of Madeira Beach.
I'm a planner with the City of Madeira Beach. My primary responsibilities include reviewing building permit applications for compliance with the land development regulations.
Are you familiar with the variance application that was received for the property 14830 North Bayshore Drive?
Yes.
And are you the person that was responsible for making a staff report and recommendation?
Yes.
Okay, if you could go ahead and present that staff report then, please.
Sure. So this afternoon we have VAR 2025-04 for Elizabeth and Jason Halloway at 14830 North Bayshore Drive, Madeira Beach, Florida. The zoning and future land use is R2, low density multifamily residential medium. And the request is to encroach into the required front yard setback with an access porch to be located 7 feet from the front property line, and an addition of a rear porch to be located within the existing covered porch footprint 16 feet from the rear property line. The specific code provisions are Section 110-206, setback requirements 1 and 2. Front yard required is 20 feet, rear yard required is 25 feet. Background. The existing single-family home was built in 1949 prior to the creation of the Madeira Beach Land Development Regulations, which created setback requirements. In 2023, a variance VAR 2023-04 and building permit 2023-207-RINT were both granted, allowing for an addition that encroaches into the required rear setback slightly further than what is currently being requested in this variance. The addition has since been completed and shown on both the survey and site plan, which is included in the support materials for this application. On November 26, 2024, as a result of Hurricanes Helene and Milton, the city sent the property owners a preliminary determination of the structure being substantially damaged. When a structure is substantially damaged, the structure needs to be rebuilt or brought into compliance with current floodplain regulations, including having the lowest living floor elevated to an elevation of at least 14 feet, NAVD in this case. In response, the owner contracted with Davy Shoring to have the existing structure elevated and submitted building permit application number 2025-2552-EELV. On February 20th, 2025, the city denied the building permit application partially due to the proposed access balconies, which encroach into the required front and rear yard setbacks. Under Section 110-93-3E of Madeira Beach Code of Ordinances, only the primary structure itself is exempt from the setback requirements of the code and only within the existing footprint. The owner met with city staff to discuss the issue. The owner agreed to reduce the size of the balcony to help meet the variance criteria and has since submitted this variance request. Criteria and analysis. 1. Special conditions and circumstances exist which are particular to the land, building, or other structures for which the variance is sought and which do not apply generally to the lands, buildings, or other structures in the same zoning district. Special conditions to be considered shall include but are not limited to the following circumstances. And the criteria that was met here are both A and E. A being that the lot is substandard or irregularly shaped. The lot has a depth of 75 feet, which is 5 feet less than the minimum building site area required in the R2 zoning district. The lot area of 3,128 square feet provided from the Pinellas County Property Appraiser's website is 872 square feet, or about 21.8% smaller than the minimum required lot area for a single-family home in the R2 district. This lot is also in a regular pie shape. Additionally, criteria E is being met, which is for architectural and/or engineering considerations. Since the building is going to be elevated, it will make it more disaster resistant, and the existing building is legally nonconforming, as the entrances will require access platforms once the building is elevated. Criteria 2, the special conditions and circumstances do not result from the actions of the applicant. A self-created hardship shall not justify variance. Findings. The substandard and irregularly shaped lot was platted before the adoption of the current land development regulations and is not the result of any actions taken by the applicant. The non-conforming building was constructed in 1949 prior to the adoption of the current setback requirements as not from the actions of the applicant. Criteria 3, granting the variance will not confer on the applicant any special privilege that is denied to other lands, buildings, or structures in the same zoning district. Findings. SMVAR 2016-08 through SMVAR 2016-13 granted variances to several other properties within the same zoning district for a reduction of the rear yard setback by 15 feet from the required 25 to 10 feet for single-family homes in the same block. These lots are all 75 feet deep, a similar depth to the applicant's property. The lots from the approved variances have rectangular-shaped lots and are slightly larger area of about 33,076 square feet per lot. The lot that is located at 14830 North Bayshore is approximately 3,128 square feet of lot area. 4. Literal interpretation would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of the land development regulations, subpart B of this code, or section 14-205 of the Code of Ordinances, and would work unnecessary undue hardship on the applicant. Findings. Literal interpretation of the code would reduce the buildable footprint of the lot since the lot depth is less than the required 80 feet and the lot area is less than the required 4,000 square feet. Many other properties in this zoning district have the ability to elevate their existing structure and add the required access stairs and balconies by right. 5. The variance granted is the minimum variance that will make possible the reasonable use of the land. As previously stated, VAR 2023-04 was granted, reducing the rear yard setback to its existing 15.32 feet. The rear yard setback being requested by this variance will be less non-conforming than what exists with this addition, and it will be within the covered porch roofline footprint, which is shown to be set back 16 feet on the site plan submitted with the application. A variance is not needed for the primary structure itself, as this will be lifted within the existing footprint, which is permitted by right under the City of Madeira Beach Code of Ordinances, Section 110-93-3E. It is also worth noting that the applicant originally proposed a rear yard setback of only 12.33 feet with an additional balcony and stairs beyond the current footprint and had to make 2 revisions to the site plan before resulting in the current proposal to meet a staff recommendation of approval. The proposed balcony in the front yard is needed to maintain access to the front door when the house is elevated and will be 3 feet wide, which is the minimum width allowed by Florida Building Code. Due to the required elevation of the building, the balcony and access stairs will need to wrap around the northeast side of the house, which due to the curvature of the front property line is currently only set back 10.76 feet. If the balcony and the access stairs were instead to wrap around the southwest side of the property, it would not encroach as far into the front setback, although it would still be encroaching, and it would create an additional encroachment into the side yard setback, which is only 5 feet. 6. Granting the variance will be in harmony with the general intent and purpose of the City Land Development Regulations, or the Code of Ordinances when it relates to Section 14-205, and that such variance will not be injurious to the land involved or otherwise detrimental to public welfare. Findings. The general intent and purpose of the City Land Development Regulations is not to unduly restrict the owner's ability to maintain or improve their property, which they are attempting to do with this variance. Furthermore, none of the proposed work should negatively impact the water flow or runoff, as a drainage plan is a requirement for the building permit. Staff recommendation. City staff recommends the approval of VAR 2025-04. And included with the application, we have including with the variance, we have the application, applicant's responses, proposed site plan, existing survey, site plan from the previous variance that the property owner obtained in 2023, along with the building permit that was approved and the posting pictures. The staff recommendation that I just read is pages 91 through 96. Pages 97 to 104 is the variance application form that was submitted on time. Pages 105 through 110 is the applicant's responses. 111 is the site plan. .112 is a survey of the current house. 113 is the previous site plan approved from 2023 variance and building permit. Page 114 is the mailing affidavit along with the mailing labels on 115 through 118. 119 is the posting affidavit and 120 is the posting pictures.
Thank you. Has the city received any letters in opposition or in favor of this application?
Neither.
Okay. I have a couple of questions relative to the photographs. So if you could turn to page 107 in the packet, looks like an aerial. Could you explain where the applicant's property is in this aerial?
Sure.
Put an arrow on it maybe so the special magistrate can see it.
Yep. So I have my mouse over the applicant's, or this one, over the applicant's property.
Okay. And what do the yellow lines depict that have been overlaid on the aerial?
I would defer that question to the applicant. This is part of what they provided with their application, but I would presume it's showing that the house is, it's highlighting where the rear property seems to be and where neighboring properties also protrude into the front setback.
Okay. And if you could turn to page 110. And can you explain what this photograph is and where the applicant's property is in this photograph?
Yes, the applicant's property is on the bottom right where I have my mouse. This photo is also provided with the applicant's application. Similarly, I think I would improve the rear line. The rear yellow line looks like the rear property line. The front seems to show that neighboring properties protrude into the front setback.
Okay. And then if you could turn to the next page, page 111. And can you explain what this exhibit depicts?
Yes. So this is the site plan that was submitted with the variance application showing the proposed elevation plans. On the right side is the proposed. So as you can see, the structure itself isn't staying in the same footprint as compared to the existing, which is on the left. In the rear yard, the applicant provided on the site plan that everything's going to be within the footprint of the covered porch, which is dimensioned to be 16 feet. And in the front yard, you can see a platform is added. That's the 3-foot wide platform that's being addressed by the variance. And the applicant has confirmed that that's not going to be any closer than 7 feet from the front property line.
All right, thank you. I don't have any other questions for Joe. I would tender into evidence pages 91 through 120 of the packet.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 91 through 120 of the application or of the hearing packet. All right, is Elizabeth Holloway or Jason Holloway here? Anybody on their behalf? Hello? Sir, what is your name?
Jason Holloway.
All right, Mr. Holloway, you've heard the city's presentation. Mr. Petraglia is recommending to me that I approve this application. This is your opportunity to ask any questions of Mr. Petraglia based on his testimony. Again, you're going to have an opportunity in just a couple minutes to tell me anything you want to tell me, but do you have any questions for Mr. Petraglia?
No questions.
All right, thank you. Don't go far. Mr. Trask, do we have any other witnesses from the
No
city?
other witnesses for the city.
All right, Mr. Holloway, what is it you'd like to tell me about this variance?
Just thank you for your consideration and looking forward to rebuilding.
All right, Mr. Trask, any questions?
No, sir.
All right, you can go have a seat, Mr. Holloway. Thank you so much. Are there any members of the public who are directly affected by this variance who want to come forward and provide public comment? Okay, seeing none, we'll go ahead and close public comment. Anything else from the city?
No, thank you.
All right, based upon the application and the recommendations of staff, I'm going to go ahead and approve VAR 2025-04. Okay, now switching gears. Welcome to the City of Madeira Beach Code Enforcement Hearing. Once again, my name is Bart Valdez. I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. Again, if you wish to speak today and you have not already been sworn in, then it is necessary that you be sworn in just a couple moments. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or landowner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and the respondent will be provided with a copy by mail. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind during these code enforcement hearings. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. All right, so if anybody wishes to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Anyone who has not already been sworn in but wants to speak to me today, please rise and be sworn. Is there anybody who didn't get sworn in the first time around? Okay. Let's go on to the first one on the agenda. It's code enforcement case number 24-71 for the property located at 129th Avenue East. Is the city ready to proceed?
We are.
All right, go ahead, Mr. Trask.
Call Mr. Pinkard as the city's first witness. Mr. Pinkard, if you could tell us what your occupation is and your job responsibilities here at the city of Madeira Beach.
I am the building compliance
Your mic on?
supervisor.
Okay.
The building compliance supervisor, and one of my duties is to issue building code violations.
Are you familiar with the property that is located at 129th Avenue East as the subject of this code enforcement case?
Yes.
Okay. Who's the owner of that property and how do you know that?
JPV Hotel Property LLC from the Pinellas County Property Appraiser.
Okay. And are you familiar with the courtesy notice of violation that was issued by the city on August 9th of last year?
Yes.
And I'm just going to refer you to page 125 in the packet. Can you explain what this courtesy notice of violation is for?
It is citing the property owner for section 110-124, standards and requirements, under the special exception subsection, and failure to comply with the special exception orders. Those are on page, looks like 132.
Okay, you're referring to the order granting special exception use that was entered by the special magistrate on June 8th, 2023?
Yes.
Okay. And in that order, does it provide that the property owner, in order to be granted the special exception use, conform to certain conditions that were established by the special magistrate?
Correct.
Okay. And can you go over those special conditions that the order requires?
Let's see. Starting under section 15 on page 133.
You can just go to the ordered section of the order.
Okay. Section 15. Do you want me to read through them?
Yes.
Okay. The standalone parking lot must be brought into compliance with the off-street parking requirements located in Chapter 110, Zoning Article 7, Off-Street Parking and Loading. The parking lot must meet the landscaping requirements located in Chapter 106, Vegetation Article 2, Landscaping, the special exception use. C, the standalone parking lot must adhere to the drainage requirements in Chapter 98, Natural Resources. D, the standalone parking lot must meet the driveway requirements in Chapter 58, Streets, Sidewalks, and Other Public Places, Article 2, Sidewalks and Driveways. And E, an approved building permit will be required to bring the property or the parking lot into compliance.
Thank you. When the courtesy notice of violation was sent out, were those conditions referred to in the courtesy notice?
Yes.
Okay, and did it provide for some type of corrective action to take place to bring the property into compliance?
The corrective action was to bring the property into compliance with the conditions underlined in the order granting special exception. And the special exception order was included with each of those notices.
And did it provide, well, first of all, what was the date that that courtesy notice of violation was issued?
It's August 9th of 2024.
And what was the follow-up date for that compliance letter?
August 23rd, 2024.
Was the property brought into compliance by August 23rd, 2024?
No.
Was there a subsequent notice of code violation that was issued by the city?
Yes.
And is that the notice that's referred to in pages 127, 128, 129 of the packet?
Yes.
Does it mirror the courtesy notice of violation?
Yes.
Does it give additional time to come into compliance?
Yes, the follow-up date for the notice of violation was March 14th of 2025.
Okay. And this letter was dated what date?
February 28th, 2025?
Okay, was this letter sent by regular and certified mail?
It was.
Okay. Did the city receive the green card back or the regular mail back from the property?
Yes, on page 131.
Okay, and what does that reflect?
That is the certified return receipt signed.
Okay. And is that dated?
That is dated March 5th, 2025.
Okay. Did the property come into compliance by the compliance date listed in that code violation notice?
No.
Okay. The city issue a statement of violation and notice of hearing?
Yes.
You could turn to page 138 in the packet. Is that the statement of violation, request for hearing?
Yes.
Okay. And did it cite the same code section
Yes.
as being violated? Was that statement of violation request for hearing sent by regular and certified mail?
Yes.
Okay, and when was that done?
April 18th of 2025.
Did the city issue an affidavit of service showing that it in fact been sent?
Yes.
Okay. And is that affidavit of service listed on pages 136 and 137 of the packet?
Correct.
And lastly, I have a question about the notice of hearing. Was a notice of hearing issued for today?
Yes.
And was that also provided to the property owner?
Yes.
And was that also sent by regular and certified mail?
Correct.
Okay. Was the property also posted?
Yes, that is on page 143.
Okay, can you point out where the posting is in that photograph on page 143?
Just beside the cone on the right-hand side.
Okay. Do you know whether or not if the property owner ever filed a application for a building permit as a result of the special magistrate's order?
Yes, I believe they did apply for a permit. The last comment that I'm aware of is the plan that was submitted was insufficient for review.
And what date was that comment provided to the property owner?
Looks like September 14th of 2023. That is on page 144.
Have there been any additional requests for a building permit application to comply with the special magistrate's order?
Not that I'm aware of, no.
All right. Can you explain to us what the picture in 145 in the packet is, page 145?
That is a picture of the posting, a notice of hearing outside of City Hall.
Okay. Do you know whether or not that these properties that are listed in the notice are currently being used as parking lots?
They are.
Are they paid parking lots? In other
Yes.
words, people that are using them are paying the property owner or its agent?
Correct.
Okay. Can this property come into compliance by having the parking lot closed? In other words, it's not used as a parking lot any longer?
Yes.
Okay. And what are the other things that are necessary for the property owner to bring the property into compliance? I realized that earlier you had cited a list of things and the special magistrate's order, but what specifically would need to be done?
I think I would defer to either of the planning department to answer those specific
Okay,
questions.
I'll ask them next then. All right, thank you. I don't have any other questions of Mr. Pinkert at this time. I would tender into evidence exhibits 121 through 145 in the packet.
All right, we'll go ahead and accept into evidence as exhibit number 1, pages 121 through 145 of the agenda packet. And Mr. Pinkert, I just have one question. I think the purpose of page 143 is to show proof of posting. And maybe this, I need to talk to a different witness, but does this picture also evidence the failure to comply with the prior order? I mean, I know that there's requirements for landscaping and other requirements. Does this picture also show that they're not in compliance with those other conditions?
Yeah, that's correct. It just shows the current condition as well.
Okay. All right. Is anyone here on behalf of JPV Hotel Property LLC?
Yes, Your Honor. Once again, Brian Ongst, 625 Court Street, Clearwater, McFarlane, Ferguson, and McMullen, on behalf of the respondent, JPV Property LLC.
All right, Mr. Ongst, you want to do any cross-examination of Mr. Pinkert?
May I approach, I've got some exhibits, some evidence here that I want to provide to the magistrate.
Yeah, show it to Mr. Trask first.
Of course.
Do they have to deal with this witness?
They may. It's a business tax receipt. So to the extent that's in his wheelhouse.
Okay. Are you going to take this other stuff off?
I'm not going to submit it.
Okay. Okay.
And I suppose I should lay a foundation first. So, Mr. Pinkert, are you familiar with the business tax receipt process for the city of Madeira Beach, or would that be somebody else?
I'm familiar, yes.
Do you actually issue the business tax receipts?
No.
Who does that?
Lisa Sherman.
Okay. What role do you play in issuing business tax receipts?
None currently.
Okay, so you're just generally familiar with it? Okay. I guess I'll wait till, you're going to present other witnesses, Tom?
Yes.
Okay, then I will end my cross-examination, Mr. Pinkert. Thank you.
All right, thank you. Mr. Trask, who's the city want to call next?
Jenny Silver.
All right, go ahead.
Jenny, if you could state your occupation here and your job responsibilities at the city.
My name is Jenny Silver. I'm the Community Development Director. I oversee building services and planning and zoning.
Okay. Are you familiar with the special magistrate's order that Mr. Pinkert was referring to?
Yes, I am.
Okay. And if, on the last page of that special magistrate's order, there's a list of 5 things that need to be accomplished by the property owner as a condition to being able to use this as a standalone parking lot. Are you familiar with those 5 items that are listed?
Yes, I am.
Can you go through each one of them and explain what the property owner would have to do to come into compliance with each one of those subparagraphs?
I can give a broad overview. Each one of these articles have a lot of detail in them, but you must comply with all of them to get a building permit. In the off-street, the comment A, let's see, you have that on. Okay, that's on the screen. What page is that? Page 134. That's the article, Chapter 110 zoning, Article 7, off-street parking and loading. There are site requirements, giving a stabilized surface as one of them. And B is Chapter 106, vegetation, Article 2, landscaping. That includes things as buffer zones and buffering for public parking lots. And then in C, there is drainage requirements in that Chapter 98. And then in Chapter 58, that has the sidewalk and driveway widths that the city has to adhere to. And all of those go within a building permit. When we receive a building permit, we review all of those standards. There was, as Mr. Pinkard stated previously, in August the 9th, 2023, we did receive an application for this property to come up into compliance. But when the city reviewed that, we submitted comments back to the applicant, and that was September 14th, 2023, that these submitted plans were insufficient for review. I believe that there was other discussions, not including myself, but some of our engineers here at the city, looking at the parking lot with the applicant in October. And then the last correspondence that I see through email was December the 1st, and we have not received any other comments on that application.
All right, thank you. I have no other questions for Mrs. Silver.
All right, Ms. Silver, I'm going to ask you the same questions about the photograph that I see on 143. Based on this photograph, does it appear this parking lot complies with Chapter 110 of the zoning, Article 7?
No.
All right, how about, does it meet the landscaping requirements located in Chapter 106, Vegetation, Article 3?
No.
All right, how about does it appear to meet, or does it appear to adhere to the drainage requirements in Chapter 98, Natural Resources?
No, it does not.
And how about the driveway requirements? Does it meet the driveway requirements?
It's hard to tell in this picture. I am not sure.
Okay. And if I understand correctly, the situation is that the owner of the property, it looks like, submitted some sort of plans in late 2023. But for those plans to be approved, the owner first has to be in compliance with my prior order. Is that right?
Yes, they would have to be in compliance with all of those 5 things, A through E, which they did not receive a building permit.
Okay. And I just want to make sure I understand we're not a chicken or the egg situation. So they're applying for a permit, but they have to, does the permit application just have to address these, I guess, 4 or 5 things? Is that the issue?
Yes. So the last thing is that E, an approved building permit, but within that approved building permit would address A through D.
Okay, I understand. Now, Mr. Onks, come on up. Do you have any questions for Ms. Silver based upon my questions or her testimony?
Your Honor, just the same foundation I'd like to ask. Ms. Silver, do you have any role in the review or issuance of business tax receipts in the city of Madeira Beach?
I do not issue, but I do know, I have some knowledge of the BTR process. You could ask me and I'll see if I can answer.
Okay, just very briefly, I'm not going to belabor this, but from a planning and zoning perspective, do you review uses that are subject to business tax receipts prior to the issuance of a business tax receipt?
Yes, we do. I don't personally, but yes, we do.
And but prior to the city issuing a business tax receipt and accepting the tax money on behalf of the operator of the business, does the planning and zoning department clear that and say that the property is in compliance and the use is compatible and allowed under the code?
Yes, when we receive an application for a business tax receipt, it goes to the planning department to review for the use.
Okay, so last question. Prior to the issuance of a business tax receipt and the city accepting and receiving the tax funds, the planning department confirms that the use is allowed and is compliant and there aren't any code violations on the property. Is that correct?
I know for the uses, I would assume also for any code enforcement or code compliance that we would check that.
Thank you, ma'am.
I have a little bit of rebuttal.
Go ahead, Mr. Trask.
So, Ms. Silver, so if the city issued a business tax receipt to JP Hotel Property LLC, does that mean that they're in compliance with all of these standards?
No, not particularly. Just because we sent them a business tax receipt doesn't mean that they received an approved building permit. doesn't mean that they have met all of those conditions. They're A through D as well.
And in fact, they have not met any of those conditions, correct?
That's correct. I'm unsure of that D with the streets and sidewalks, with the driveway requirements, but other than that, they do not comply with.
All right, thank you. I have no other questions.
All righty. Anybody else on behalf of the city?
No other witnesses from the city.
Mr. Trask, I don't know, maybe I missed it. Time for compliance and proposed fine on this one, if I find there's a violation.
So the city is going to recommend that the property owner be given 30 days to come into compliance. Should he fail to come into compliance within that 30 days, that he be subject to a $250 a day fine.
And just so the record's clear, Mr. Trask, I want to make sure compliance is either close the property or bring the property into compliance with the 5, I don't know if I called them conditions or requirements of the special exception.
Conditions.
Yeah, conditions.
So there's two ways the property can be brought into compliance: that it stop being used as a parking lot, or they comply with the 5 conditions that were set forth in your order.
Okay, I just want to make sure that was clear on the record. All right. All right, Mr. Ungst, your opportunity to tell me anything you want to tell me, make any arguments, call any witnesses, show me any evidence you want to show me.
Thank you, Your Honor. May I approach?
Absolutely.
And once again, I've shown these documents to Mr. Trask, and I've got copies for him that I'm going to provide as well.
Okay, thank you.
Thank you.
I also have some code sections here I want to provide just for reference. Again, have copies for Mr. Trask as well. Your Honor, may I proceed? Yes. Thank you, Your Honor. So succinctly, to give you the actual what's going on here with this piece of property, this property is in the Johns Pass Village Activity Center. The applicant and the city and the community have been working on that activity center and the comprehensive plan for many years. And that process took roughly 3 years to complete with Pinellas County, for Pinellas and the city. You know, my applicant or my client was, proactive member of the community that participated in that process and is helping, in his mind, the city achieve the planning elements that it wants to achieve on this property, particularly in the activity center. To that effect, I can tell you, and he can testify to it, that we are imminently submitting a PD application for a plan development for a hotel use, which would include structured parking, which will include parking that, again, would be consistent with this current use, but improved into structured parking with hotel use over top. City's aware of that. That's just for your information, Your Honor. So I don't want you to view my client as someone who is not active, not responsive, just totally out to lunch and thumbing their nose at the city. He's working proactively in many areas with the city on many different parcels. And again, we believe consistent with the comprehensive plan and the goals and objectives of the city and of the planning department. So in this particular case, Your Honor, Mr. Carnes, JPV, did submit a building permit application after your order in 2023. For whatever reasons, Mr. Carnes was unaware or felt like that process was still moving forward, and thought that he was waiting for some comments back, I believe, from the engineering consultant regarding that. Having said that, Your Honor, again, and I can show you, the city has issued a business tax receipt for these parcels. It's, these parcels are should be really unified. They're not unified yet, but it's one cohesive use. This is a parking lot that's managed by UPP Global LLC, a parking management company that's very familiar to the city. And the city issued a business tax receipt in 2023 through 2024, and then sent an invoice again for business tax receipt 3950 in September of 2024, which was paid just prior to Hurricane Helene. And when you look at the code sections that I provided you, Your Honor, And in my experience, you don't get a business tax receipt unless the city establishes that the use is consistent and there are no code violations. There's no zoning or development review process that needs to occur. And then when you look through what happens to revoke a business, once the city issues a business tax receipt, what is the proper process under the black letter law of the code to close that business or to revoke that business tax receipt? And that has to go to the Board of Commissioners pursuant to Section 62-57 of the code. So the city's already issued a business tax receipt, has already accepted the tax funds. So purely from a legal argument, Your Honor, my argument would be, from a legal perspective, under the process, under the code, the first step to get back to Your Honor for code enforcement and to levy a lien on the property for a violation would be to first go back to the city commission and have the business tax receipt revoked, because the business tax receipt is what legally establishes the business and allows the business to operate within the city. You cannot do business in Madeira Beach without a business tax receipt. So from this perspective, the respondent felt like they were following the process. They were paying their taxes. They got their business tax receipt. This isn't a use that was just established fly by night. They haven't changed the character of the use since the business tax receipt was issued. So it's not like they put some non-conforming structure on the lot. So that's my legal argument, Your Honor. To the extent that you agree from a process perspective that this should go to the Board of Commissioners first, that would be my argument that I would advance to Your Honor. To the extent that that argument's not going to fly today, and you do find them in violation and you do want compliance, we would request that you would allow us time to go back into that permitting process, understanding that these improvements are going to be ripped out. And it's, again, going back to the practical argument here, or not the practical argument, the practical facts of the situation is whatever money they spend to landscape and drainage and pave, all of that's getting ripped out in short order for the PD. So we would request that if we had a PD application active, that code enforcement would forbear. If we have a building permit application active that's sufficient for review, and let's make that the condition. If either of them are sufficient for review, a PD application within 30 days is sufficient for review, or a building permit application that's sufficient for review, that the code enforcement would forbear. And if the city's ultimately the outcome is our least preferable outcome, which is they do have to invest in improving this parking lot with improvements that are going to be ripped out, we would like to not have to start that construction until after the season, which would be after this summer. So sometime in the October, November timeframe, Your Honor, preferably November.
All right. I understand the legal argument. I may have some more questions about that. Do you want to call any witnesses or present any other argument or evidence?
You want to say anything? You don't have to. You can say that if you'd like.
Hey, good afternoon, sir. Just give me your name and your relationship with this LLC.
William Carnes, and I'm one of the managers of the LLC.
And tell me again, I know I've seen you before. How do you spell your last name?
Karns.
Gotcha.
You look a lot younger than the last time I saw you.
I don't know about that, sir, but all right, what do you want to tell me? I understand your lawyer's argument, but what do you want to tell me about this situation?
Well, I did apply for the permit shortly after the last hearing. As Holden had explained to you, the city engineer, I believe it was Al Carrier who was working on that, and I was in communication with him. He simply just said that the plan was insufficient that we submitted. Didn't tell me what was insufficient about it or anything like that. So I don't know how to correct the plan if I don't know what was incorrect with the plan that was submitted. So I'd like to get the permit pulled. I understand it's just a big waste of money to go ahead and do any work on that property when whether the PD gets approved or not, we're building something on that property. Property's not going to sit there. Property's been in that same condition for over 15 years. operated as a parking lot way before we ever purchased it. So I want to do whatever's best for the city, whatever's best for our development. And right now, the parking lots are full on a regular basis. They stay full through the summer. So certainly wouldn't want to tear up the parking lot because it affects businesses that I rent to all along the boardwalk that I own property to. That's where they park to go to eat at Caddy's or go to Scully's or go to the fish market at the east end of the property. We own that Don's Dock property down there, and that's where the people park. So it certainly doesn't make any sense to eliminate all of the parking at high season when this is something that we could do in October or November. But I need direction on how my plan was incomplete, insufficient. What's that mean?
May I ask one question to Mr. Carnes? Mr. Carnes, when do you believe that you will have this PD application submitted? What's your time frame for submitting the PD application?
It's any day now.
Within the next 30 days?
Absolutely.
Thank you, sir.
All right. Mr. Trask, do you have any cross-examination, Mr. Carnes?
I do.
Go ahead, sir.
Mr. Carnes, you're a general contractor, correct?
Yes, sir.
How long have you been a general contractor?
44 years.
Okay. How many building permits have you pulled here in the city of Madeira Beach in the last 10 years, approximately?
40 maybe.
Okay. So you're familiar with the process then when you get comments back on an application that's been submitted, what you need to do to bring the application in compliance, correct?
Absolutely.
Okay.
As we all know, Mr. Trask, comments aren't forthcoming.
So in the portal, there is a link that provides on Thursday, September 14, 2023, to whom it may concern, and it provides a response to the application. Did you receive that?
I don't, someone in my office handles that. I don't handle that myself.
All right, so someone in your office handled that response that came from the city?
If the one you're referencing is the one that says the plans are incomplete, is that the one you're talking
Yes.
about?
Yeah.
Okay, yeah.
The answer is yes.
Yeah,
Okay.
what's that mean though?
So did
And I
you,
called Mr. Carrier and I asked him to please send me a detailed list of anything that's not complete on that set of plans. And as you can see in the portal, there's no activity since then.
did you read that letter?
Yes,
Okay, so you understand then, and it's been received into evidence, the letter says, per the order granting special exception used to allow vehicular parking on the boardwalk properties, requires the standalone parking to be brought into compliance with the city code of ordinances regarding off-street parking and loading, landscaping, and stormwater requirements. The submitted plan is insufficient for review. You're aware of that, right?
that's exactly what I'm talking about.
Okay.
It doesn't state what's insufficient about it.
Okay.
I've done this for 44 years, Mr. Trask.
So approximately how many cars park on this parking area on a day-to-day basis?
I believe there's approximately 170 parking spots on the property. Cars come and go throughout the day. So I couldn't tell you how many cars per day park there.
So what is the income that JPV Hotel Property LLC receives from these parking lots on a monthly basis?
Your Honor, I'm going to object. I'm going to object. This is outside the scope of direct, and it's not relevant to the code enforcement issue before, Your Honor.
I think I understand where
respond?
he's, go ahead.
The reason I'm asking is because if you're going to associate in a dollar fine associated with the violation, if in fact that it's low enough, then the property owner could continue to pay the daily fine and keep the parking lot open. So I think it's appropriate in regard to how much money is actually receiving in relation to the daily fine of $250.
And I do think it's relevant for that purpose. We ask the same question when people are doing VRBOs. So you don't have to answer if you don't want to. I can't force you to answer, but I'd like you to answer.
I don't mind answering it because I don't have any idea how much the parking that UPP collects. I know that we rent UPP the parking lot, and I know what we receive on a monthly basis for that.
Okay, what do you receive on a monthly basis then?
About $47,000.
Does that include all the lots together?
That's correct.
Okay. All right. I don't have any other questions.
And I believe that includes the tax.
Okay, thank you.
All right. First of all, I'll go ahead and accept into evidence as Exhibit 2 the 4 pages of information that you provided, Mr. Ongst.
Thank you, Your Honor.
Also want to give you the opportunity, is there any follow-up you want to have with Mr. Carnes based upon Mr. Trask's cross-examination?
No, Your Honor.
Okay. All right. Mr. Ongst, are there any other witnesses you want to call today?
We have no other witnesses.
All right. Mr. Ongst, I'll start with you since it's your argument, but Mr. Trask, I'm going to give you an opportunity. I have read the ordinances, the ordinance that you cited, Mr. Ongst. I follow your argument. Are you aware of any case law reported at an appellate level or even circuit court decisions on this argument that you're making? Because I don't know if I necessarily see in this ordinance what you're arguing, but is there any guidance that you can give me from any court that's passed on this issue before?
Your Honor, I mean, the notice of hearing that I got was the first notice that I've received of this, and that was from April 21st. It's dated April 18th. My client received it April 21st. So I'm just becoming aware of this entire issue and this entire history. What I know is, in my practice, whether it's Madeira Beach or Clearwater or St. Pete, you don't get a business tax receipt if your property is not in compliance, or if your use needs a special exception, or if your use needs, some kind of public hearing. Or development review process. So from my perspective, when a city issues a BTR, it's certifying that that business is legally allowed to operate, whether it's from a planning perspective, an alcohol zoning perspective, a height, density, setbacks, any of those types of perspectives. And what the code in Madeira Beach says, and this is maybe peculiar to Madeira Beach, Your Honor, because I can tell you I've not seen this particular code section anywhere else, not to say it doesn't exist. But what Madeira Beach says is, if the operation of a business is contrary to the provisions of the code, it first must go back to the Board of Commissioners to retain the right to revoke the local business tax receipt. And so that's the process I think the city should have started with here. But again, that's purely a legal argument, Your Honor. And I do not have any appellate case law. If you want to give us another month, I can come back with a brief for you. I'm not being sarcastic. I mean, if it's something you're interested in, I'm interested in it as well. We can do that. If you're going to rule today, you've heard our argument, Your Honor.
I appreciate that. Mr. Trask, I'll give you the same opportunity. Can you provide some insight on this? I hear the argument. I don't see in this ordinance, but is there any case law that you can point me to, or any other argument you want to make on that particular issue?
First of all, I'm not aware of any case law that falls in line with what Mr. Unks was arguing to you as a special magistrate. But to me, I think this is just a red herring. We're not talking about the use of the property right now. We're talking about whether it's in compliance with the order that you had entered 2 years ago. So this is 2 years that they had to come into compliance and, in fact, have not done so. So I don't believe that argument should hold any water. You've heard testimony from 2 city employees that the property is not in compliance with your order, and I think that is sufficient enough to prove that there is a violation of the cited code section. I'm very concerned about the fine if you find that there is a violation here. Even at $250 a day times 30 days in a month, it's $7,500. So the business is receiving $47,000 a month. The fine can be a maximum of $7,500. We're still asking for that, but I'm hoping that Mr. Carnes would do the right thing and close the parking lot down, either that or bring it into compliance within those 30 days. So, but otherwise, the city will be expecting a check on a monthly basis for $7,500.
All right, and Mr. Trask, what's the response to Mr. Unk's argument about if a PD application or a building application is submitted, how, do you have any response to that or how I should treat that? I understand the argument he's making. Look, if I'm going to build a hotel on this, why spend all the money to make a big parking lot? I get that argument. I don't know if that's not before me today. It's not whether a code provision has been violated or not. I just want to come up with a practical solution to that issue.
I think Mr. Carnes made that same argument 2 years ago when we heard the case the first time. You'll remember that he was a witness in the case, and it is actually, his name is actually referenced in the order that you had entered, that he was here and testified, and I think that that was their intention 2 years ago. I know that I have been familiar with Mr. Carnes's desire to build a hotel in Johns Pass Village for at least 10 years. So this is not something new. I know he's working on it, but I don't think it has any relevance. 2 years ago, he had the same capability of making those arguments. I don't think that they were successful then. I don't think that they should be successful now. We need to get the property into compliance so that it complies with the city code.
All right, thank you. All right, are there any members of the public that have knowledge of this code violation that want to come forward and provide any testimony in regard to this particular code proceeding? All right, seeing none, we'll go ahead and close public comment. All right, based upon the testimony of the city staff and the evidence, I'm going to go ahead and find that there is a violation. These 5 conditions have not been complied with. Mr. Unks, I followed your argument, if you find case law and you want to file a motion for reconsideration or rehearing of my order, I would welcome that and certainly hear that at one of our next meetings. So I'm going to go ahead and move forward with an adjudication today. But again, I want to get this right. I want to follow the law of the state of Florida. And if there's a judge out there or appellate panel that have already ruled on this, and I'd very much like to see that, you're welcome to file that brief. I'll give you 10 days to do that. Mr. Trask, I'll give you another 10 days after that if you want to file anything else in response or in reply to whatever Mr. Unks files. And that still gives us time, before the next hearing if I need to bring it up. Mr. Unks, I understand what you're saying about the timing. I'm willing to work with you a little bit on the timing and give you 60 days to bring the property into compliance, and then a $250 a day fine after that. What I'll also say is, as I do in all my orders, I'll reserve and preserve jurisdiction. If you want to come back in and you want to make an argument that my fine should be abated, reduced, or something like that, based upon some new information or some development plans or some submissions or building permit submission, I'm here every 30 days, and I'd be more than welcome to hear that. You just have to coordinate it with Mr. Trask so that it's properly noticed and can be put up for a public hearing. But again, please feel free to do that. You can get all my information from the city or online, of course. So, all right. We'll move on to the next one, which is code enforcement case number. I don't know if it's, make sure I got the case number right. Mr. Trask, what's the case number on this one? Is it just 122?
No, it is not 122.
Okay.
So the case number is, let me find that. I'm not seeing a case number. So this is the property that is located at 13715 Gulf Boulevard. The property owner is John Volpe, as trustee of the John Volpe Revocable Living Trust.
That's what I have. So, okay. So the next hearing we're going to move on to, Mr. Volpe, if you're in the audience, we're moving on to your case. It's the case for the property located at 13715. Mr. Trask, the city ready to proceed?
Yes, the city would call Holden Pinkard. Mr. Pinkard, if you could state your occupation and your job responsibilities here at the city of Madeira Beach, please.
Building code compliance supervisor, and one of my duties is to issue building code violations.
Are you familiar with this property that is located at 13715 Gulf Boulevard?
Yes.
Okay. Who's the owner of that property and how do you know that?
John Volpe and the Pinellas County property appraiser.
Okay. And what is this property in violation of?
The sections cited in the courtesy notice are for maintenance of the exterior. That's section 1469. and general maintenance, which is 1470.
All right. Did the city issue then a courtesy notice of violation? And if so, what was the date of that notice?
Yes, and the courtesy notice was mailed on February 28th of 2025.
Okay. And when this courtesy notice was sent, did it specifically provide, besides the code sections you just mentioned, the violation detail and a corrective action needed to be taken by the property owner?
Yes.
And what was that?
The building on the property is in a state of disrepair, and to correct the violation, the owner or licensed contractor will need to apply for and obtain a building permit. If a permit cannot be obtained, the structure must be removed.
Okay. Did this letter provide the property owner with a follow-up date?
Yes, March 14th of 2025.
Did the property come into compliance by March 14th?
No.
Okay. When the courtesy notice of violation was sent, did it attach photographs to the courtesy notice?
Yes.
Okay. Could you go through those photographs that were attached to the courtesy notice of violation?
Sure. Page 152 is a posting of I believe that is an unfit placard.
Unfit for human habitation?
Correct.
Okay.
Page 153 are interior pictures of the wall where you'll see the back part of the home is separating or sinking. This is more separating of the concrete and the wall and the supporting foundation on page 154. More separation on 155. And that is 155 is a close-up view of the photos on 156. Here you can kind of see the, I guess, sagging of that where the deck meets the back of the house on the second level.
Okay. And if you could turn back to page 154 and 155, it looks like there's some type of jack that has been added underneath that overhang. Is that correct?
Yes.
Okay, what's the purpose of that?
My assumption is either the owner or someone is trying to brace that part of the building to keep it from falling down.
Okay. Once this letter was sent out, was it just sent out by regular mail?
The courtesy notice was sent regular mail, and the notice of code violation was sent certified.
Okay, let's go to that then. If you can turn to page 157. This notice of code violation mirrors the courtesy notice as to the code sections that were cited?
Yes.
Okay. And could you go through the specifics relative to the subparagraphs that are listed in the notice of violation, specifically under section 1470, why certain subparagraphs are listed and not all of them?
Grace Mills was the author of this letter initially, but the subsections all relate to structure and structural members. Section 40-70, same general maintenance. The section 2, floors, interior walls, and ceilings of every structure shall be structurally sound. 6, supporting structural members are to be kept structurally sound, free of deterioration, and capable of bearing imposed loads safely. 7, walls and ceilings shall be in good repair from excessive cracks, breaks, loose plaster, and similar conditions. And walls should be provided with paint, wall covering materials, or other protective covering. Section 11, foundation and walls shall be maintained structurally sound, free from defects and damage, and capable of bearing imposed loads safely. And 13, exterior porches, landings, balconies, stairs, and fire escapes shall be provided with railings properly designed and maintained to minimize the hazard of people falling, and the same shall be kept structurally sound, in good repair, and free from defects.
When the notice of code violation was sent, were the same photographs attached to that notice?
Yes.
Okay. Did you receive, well, first of all, you sent that by certified mail?
Yes.
Did you receive a response? In other words, the green card back?
Yes, that is page 166.
Okay. After the green card was received back, did anyone from the property, any of the property owners come to the city and follow up as to what needs to be done to bring the property into compliance?
Not that I'm aware of. There is a separate report from an engineer that visited the property. But personally, reach out to me or contact me, no.
Okay. In this notice of code violation, did the city give additional time to bring the property into compliance?
Yes, give me one sec. Yep, so the follow-up date was March 31st of 2025 for the notice of violation.
Did that occur?
No.
Did the city issue a statement of violation and notice of hearing for today?
Yes.
If you could turn to page 178 and 179 of the packet, is this a statement of violation that was issued?
Yes.
And did you also, the city also issue a notice of hearing for today's hearing?
Yes.
Is that reflected on pages 180 and 181?
Correct.
And how were they sent to the property owner?
Regular mail, certified mail. The property was posted, and the notice was also posted here at City Hall.
And that's reflective in the affidavit of service. It's on page 176 and 177 of the packet?
Correct.
Okay. And if you could just explain to us then what the last couple of photographs are in the packet, which would be pages 183 and 184?
183 is the posting of the notice of hearing at the property, and 184 is a picture of the notice of hearing posted here at City Hall.
Is the property being lived in at this point?
That I don't know.
Okay, but it's been posted so that nobody should be living in it, correct?
Correct.
All right. Is the property still in violation then?
Yes.
Okay. Do you have a recommended time frame for the property owner to bring it into compliance, and if not, what the daily fine should be?
Based on the condition of the property, I'd say 14 days.
And the daily fine?
The $250 a day.
And why on the high end of the range for the daily fine?
Due to the life and health safety concerns.
Okay. Thank you. I don't have any other questions. For Mr. Pinkert, I would tender into evidence pages 146 through, I think it's 164. No, I'm sorry, 184, and ask that they be received into evidence.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 146 through 184 of the agenda packet. Mr. Pinkert, I just want to make sure I understand the corrective action. So is it to either obtain a building permit and make all the necessary repairs? Is it to demolish the property? Is it to, because I noticed in the statement of violation said to get an after-the-fact building permit, but I just want to make sure that the record's clear as to what compliance looks like for the owner.
Yeah, to either apply for and obtain a permit to make the necessary repairs to make it safe or remove it.
Gotcha. All right, Mr. Trask, I'm going to come back to you at the end if you want to add or clarify anything on that. All right. Want to make sure I called Mr. John Volpe, but I know there's other respondents. Is anyone here on behalf of any of the owners, John Volpe, Jennifer Volpe, or Teresa Volpe?
I'm John Volpe, Your Honor.
All right. Hello, Mr. Volpe. How you doing today?
Good. I would like to say, Mr. Trask, and to you, we filed for a permit of demolition. We're trying to have that part demolished and taken care of. I haven't received mail there's no mailbox here, got washed away in the flood. No one has lived in the property since September 26th. You know, it's uninhabitable. And we know that. We're not trying to do that. And we're not trying to drag it out. We had insurance litigation going on, which I'm sure you all heard about from many, many different people. What we're trying to do is get the permit. We filed for the permit on April 25th and for permit of demolition. And we want that back area that you've seen removed. And I've had it cautioned, yellow tape cautions wrapped around it. It's secured. You can't get in it. You can't get out of it. I had the driveway blocked off so no one can get back there. We've been trying to remove stuff, as we can, as best possible. We lost everything. I used to live on the first floor of there. Lost everything, lost the 2 cars in the back, and been trying to do the best that I can do. I had no place to live for 3 months, and we're just trying to make the best now. Like I say, we filed on Friday for a permit of demolition. I have litigation going on with the insurance company, but we're going to pay out of our own pocket to have the demolition done. So I'm going to try to comply as best I can with anything that we can do.
All right. And Mr. Volpe, I heard everything you said. I appreciate that. You have the right to ask questions of Mr. Pinker. Do you have any questions you want to ask of him?
Well, I think he summed it up. He's trying to do the best he could, and the way he understood, he didn't know if someone lived in there or not. I can understand that. But there has been no one in it since the storm, since Helene, September 26th.
All right. Thank you, sir.
We had 5.5 foot of water in the first floor alone.
Oh, wow. Okay.
So it's just been so hard to even catch up. And as I'm sure all of you have heard, the insurance companies are giving very, very difficult time, but we're getting less than a third of what we thought we were going to receive. So we're trying to, dig in our own pockets to stay above and do what is required to make the place safe. But like I said, we tried to keep it as safe as possible. They can't get in the driveway. We had yellow caution tape on the whole place. There's no way to get in the building. The doors have been all screwed, locked, so, and we're not trying to drag our feet. We're trying to comply as soon as we can. I wasn't even receiving mail for like 3 months because I had no place to live. I was living out of a truck. It was just very difficult. But I mean, I know you've heard the story from probably hundreds of different people, but I'm not trying to, I'm not trying to drag my feet on this or anything. It's just
No, I'm sure
hard.
the city appreciates that. So, Mr. Volpe, any other documents you want to show me, any other witnesses you want to call at this time?
No, that's about it.
All right. Mr. Trask, do you have any questions of Mr. Volpe?
Just a few. Sir, how much time do you need to bring the property into compliance?
Well, if I get the permit for demolition, I have a licensed demolition man that can come out and start the process. I want to make sure I'm doing it legally. And like I say, I applied online on Friday for it. And I also did send an email a while back trying to explain. I wasn't trying to ignore anybody. I called the city here many times, but I couldn't get through. So then I sent the email, but I didn't get any answer from that. I don't know if it got lost or whatever, but I got a copy of it here. But I'm not, it's here nor there. But anyway, like I say, I'm willing to go forward. We're going to pay out of our own pocket. So if they give me the permit for demolition, I will proceed as soon as I can.
So the city is suggesting 14 days to get that permit. Do you think that's sufficient enough time for you to get that permit?
Well, does the city know the sooner they get me the permit, the sooner I can get the man lined up to get out there. Now, as far as the scheduling goes, you know how all these contractors and everybody are all tied up with everything in the whole area. So I'm trying, I want it as soon as possible.
Okay. All right, thank you.
All right. And Mr. Trask, for purposes of my order, is my order that he has the compliance would be obtain the building permit within 14 days or demolish the structure in 14 days? I just want to be clear on what the city's asking for.
He needs to be in compliance with section 1469 and 1470, whatever it takes.
Okay.
And maybe I can add a little bit with that. What we would like to do is if we get the permit for demolition, we would like to have that dangerous area taken down for the start, the first most, as soon as possible. And then if we need to go in to have a permit for the existing structure, obviously we'll go for that.
Yeah, I think that's a different issue, isn't that, Holden? The remainder of the house?
I guess is the demolition permit for the entire structure? Is what you've applied for is for the entire structure?
No, it's actually for that back section you see that is falling off.
And how is the rest of that second floor going to be supported in the meantime?
That was all block in there. The whole, that was an addition, and the city had okayed it. We had all the paperwork, all the license, all the permits, and we were putting in steel beams, and they insisted upon laminate beams. And over the time, that's been about maybe 12 years, 13 years, the laminate beams failed. And that is what happened. We were putting steel beams in, but they insisted, and I got the paperwork for it, that we put laminates in. And over time, for whatever reason, they failed.
Okay, but it's not your intention to tear down the entire house?
Not the whole house, no, we're going to leave the footprint.
All right, so your testimony then is that the remainder of the structure, other than what it is on the overhang, is concrete block. You're not going to touch that, other than you're going to remove this addition that is on the backside.
Well, obviously, we're going to have a structural engineer come in and tell us what needs to be done to make it safe.
But it's not your intention to demolish the
No,
building?
not the whole place,
Just,
no.
just this portion that's overhung?
Correct.
The back, okay. All right.
All right, thank you, Mr. Volpe. Are there any members of the public that are familiar with this code enforcement proceeding that want to come forward? Okay, seeing none. Mr. Volpe, I'm going to go ahead and give you 14 days. I'm sure the city appreciates that you've already submitted an application. Like I said in the prior hearing, if for whatever reason that 14 days isn't workable for you because either there's some delay in issuing the permit or there is
Well,
some
you know
problem.
what I would like, if it would be okay with you, if you could put 30 days on it now, depending on how the permit is issued, and I would like to schedule my demolition man to come out. I've always had him look at it, and he says he could do it. I just want to make sure he gets it in that time frame, and 14 days is a little short to, just jump right into it, because I don't know his schedule.
All right, I'm going to give you 30 days based on your representations that you've secured the property and that it's, people can't get onto the property. Thereafter, it'll be a $250 fine per day.
Thank you, Your Honor.
Again,
I appreciate that.
if there's an issue that you have, but you want to come back before me because there's some unforeseen delay, just please make sure you do that.
I
And
appreciate
you
that.
can ask
Thank you
city.
very much.
You may also want to, if you have any other questions, I don't know if Mr. Pinkert has other items on his calendar today, but you may want to hang out here in the back until after this hearing is over. I'm sure the city staff might be willing to talk to you today. Again, I don't know what Mr. Pinkert's schedule is, but you may want to just
I
hang out
appreciate
till the
that.
end of the hearing today.
Thank you very much for your time.
All right. Let's move on to the next one, which is case number CE 24-238 for the property located at 265 East Madeira Avenue. Is the city ready to proceed?
Yes.
Go ahead, Mr. Trask.
So we call Mr. Pinkert again. Mr. Pinkert, this case is on the property located at 265 East Madeira Avenue. Who owns this property and how do you know that?
Sorry, one second here. Randall Keys, the Pinellas County Property Appraiser.
Okay, and this property was cited for what code violations?
All right, so this was section 14-69, same maintenance of the exterior of the premises, and then 1470, general maintenance. Subsections number 2, 6, 7, and 11.
Okay, those are similar to the code sections that were cited in the last case dealing with structural portions of the home?
Correct, they are
All
the
right.
same.
And so did the city issue a courtesy notice of violation?
Yes,
What date was that?
March 4th of 2025.
Okay. Was that sent by regular mail?
Yes,
Okay, and did it provide what the details of the violation were and what corrective action was to take place?
yes, the detail was just that the building on the property was heavily damaged and maintenance was needed. And the corrective action is either the owner or licensed contractor will need to apply for and obtain a building permit to bring the property into compliance. And if a permit cannot be obtained, the structure must be removed.
Did you give the property owner some time to come into compliance?
Yes, approximately 2 weeks, and the follow-up date was March 18th of 2025.
Okay, did the courtesy notice contain photographs when it was sent?
Yes.
And could you go through those photographs starting at page 191 of the packet?
191 is a picture of the unfit for occupancy. And 192, somewhat hard to see, but you can see portions of the home that are damaged. And my understanding is this property also, there was a fire at this property. 193 is more damage of the ceiling, door, walls. And 194 shows some of the fire damage.
Is the roof caved in that photograph?
Yes.
Okay. The property didn't come into compliance by March 18th then, correct?
Correct.
So the city issued a notice of code violation on March 24th?
Correct.
Is that the notice on page 195 of the packet?
Yes.
Did it include the same photographs and the same code sections in that notice?
Yes.
Okay. And in that particular one, it gave the property owner until April 7th to come into compliance, correct?
Correct.
All right. And the property owner did not do that, right?
Correct.
So when the letter was sent, the courtesy notice, the regular notice of violation, did the city receive the green card back?
Yes.
And is that on page 203 of the packet?
Correct.
Okay. Did the city subsequently issue a statement of violation and request for hearing?
Yes.
Is that on page 210 of the packet?
Yes.
The city also issued a notice of hearing for today's hearing?
Yes.
Is that on page 212 of the packet?
Correct.
Now, how were the statement of violation, the notice of hearing sent to the property owner?
Regular mail, certified mail. The property was posted, and the notice was also posted here at City Hall.
Okay. Have you, or has the city received any correspondence or contact by the property owner?
Yes, I have, and there is a permit application in now. We need one form until we need to issue the demo permit, and I'm hoping that will happen as soon as tomorrow.
Okay, so there's a very good likelihood that the property owner can bring this property into compliance by demolishing the home within the next couple of weeks?
Yes.
Okay. All right, a couple of more questions. Can you explain to us what the photographs are on the last two pages of the packet? Looks like 215 and 216.
15 is the posting of the notice at the property, and 216 is the notice of hearing that was posted here at City Hall.
Okay. All right, thank you. Do you have a suggested time frame for the property to be brought into compliance, and if not by that time, what the daily fine would be?
I think same as the previous case, the 30 days,
And the daily fine?
the 250.
And what's the reason for the high end of the dollar amount of the fine?
Just due to the life and health safety concerns.
Okay. But there's nobody living in this home at this point, correct?
No.
Okay. All right, I have no other questions for Mr. Pinkert. I would tender in evidence documents in the packet 185 through 216.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 185 through 216 of the agenda packet. All right, Mr. Keys or anyone on behalf of the owner, are you here today? All right, come on forward, sir. All right, sir, are you Randall Keys?
Yes, sir.
All righty. Just as the other people, I'm going to give you an opportunity in just a few minutes to tell me anything at all you want to tell me about this violation. This is your opportunity to ask Mr. Pinkert any questions about his testimony. Do you have any questions for him?
Not really, no, sir.
All right, thank you. All right, Mr. Keys, what would you like to tell me? You can call witnesses, you can tell me what you want to tell me, or give me any evidence you want to give me.
I came in and applied for a permit immediately after the hurricane, after the building caught on fire during Hurricane Milton due to a Duke Energy power surge. I corresponded with the fire department. They sent over a fire marshal from Orlando that determined that it was Duke Energy that did it. However, they cannot be held liable because anything that happens during a named storm is considered an act of God. So the place burned. I came in shortly afterwards and applied for a permit. Unfortunately, the property, as well as my residence, are in the name of a trust, and a building permit cannot be issued to anyone in the name of a trust. So I got in touch with Grace. I talked to her. I talked to Al Carrier about having the, recommending an engineer to analyze the walls to see whether I could build on top of the existing walls if they were structurally sound enough, which they are not. I also would like to have some soil testing done to see whether I leave the slab there or not, or have it all done at once. In any event, I switched the property over last week into my own personal name out of the trust, so I could apply for the building permit. I had previously had 2 other contractors, one of which put a silt fence around the property, and told me he was applying for a permit. He did show me copies of his insurance that he allegedly sent to the city. I don't know if he did or not. But so 2 contractors I had to try to get permits while it was still in the trust. That's why I switched it out of the trust, so I could be much more active in trying to get this taken care of. Holden's aware that I have applied for a permit in my own name, and I'd like to get things going, but as Mr. Volpe also said, contractors are, as I can tell you, 2 of them are incredibly irresponsible. And I also have a couple questions for all of them when I do talk to them. The lot's only 40 foot wide, so getting a dumpster there, and as well as their equipment, which has got to come in on a trailer, and the road is incredibly narrow. Even the garbage trucks back down this road. It is so narrow, but I'm hoping to get things done as quickly as I possibly can.
All right, thank you, Mr.
I have been, also affected by the storm. I had 4 foot of water in my home, which is also in Madeira Beach. I lost my truck, 2 boats, and I definitely feel a little bit of PTSD as a result of these storms, and lost all my tools. So anything that I was attempting to do, I couldn't do. And it's been rough on everyone.
All right, thank you, Mr. Keys. Mr. Trask, do you have any questions for Mr. Keys?
No, sir.
All right. All right, any members of the public that want to, or first of all, anything else, Mr. Keys, any other documents or any other witnesses you want to call?
No,
Okay.
Holden has most of the documents.
All right. Are there any members of the public that have knowledge as to this code violation that want to come forward? All right, seeing none, we'll close public comment. All right, Mr. Keys, based upon the testimony and evidence, I'm going to go ahead and find the property in violation. You'll have 30 days to either apply for and obtain a building permit to make the repairs or to get the building permit for the demolition. As I said in the prior hearings, if for whatever reason you have a difficulty complying with that deadline, please make sure you communicate that to the city. You can come back before me, whether it's a delay in issuance of the permit or a delay in finding a contractor to actually do the demolition, then just please get back before me as soon as possible. Once the property is in compliance, please make sure you notify the city that the building has been demolished so the city can do an affidavit of compliance, okay?
Yeah, there's no repairing this structure.
Yeah, it doesn't look like it. So best of luck to you, sir. Sorry about the misfortune and good luck on getting it demolished.
It was half my income was from the rental of that duplex.
Good luck, sir.
I had also talked to Joseph earlier regarding, the rebuilding, what I need to do in order to keep it as a duplex because it's on a non-conforming lot. and he said I would be grandfathered in as long as I began construction within a year. And so I'm working at that goal also.
I think you'll find that city staff will want to work with you to bring this property into compliance, sir.
All right, thank you.
All right, thank you. All right, let's go on to the next case, which is case number 24-254 for the property located at 433 Boca Ciega Drive. Is the city ready to proceed?
Yes, we are.
Go ahead, Mr. Trask.
Calling Mr. Pinkert again. So, Mr. Pinkert, if you could state your occupation, your job responsibilities here at the city, please.
Building compliance supervisor, and one of my duties is to issue building code violations.
Okay, today we're here on a property that is located at 433 Boca Ciega Drive here in Madeira Beach. Are you familiar with that property?
Yes.
Okay. Do you know who the owner of that property is, and how do you know that?
Shirley A. McFarland, and from the Pinellas County Property Appraiser.
Okay. And I noticed that there is a courtesy notice of violation that was issued by the city on March 5th, 2025. And it was addressed to someone in Highland, Michigan. What was the reason that the notice was sent to that address?
That is the address listed on the Pinellas County Property Appraiser, or the mailing address.
What was the property owner cited with in that courtesy notice of code violation?
The same as the last two cases. Section 14-69, maintenance of the exterior, and section 14-70, general maintenance, sections 2, 4, and 11.
All right. And did the courtesy notice provide a violation detail and any corrective action that needed to be taken?
The detail, the building on the property is or requires interior and exterior maintenance due to damages. And the corrective action is the property owner and or licensed contractor will need to apply for and obtain all required permits to bring all violations into compliance. And if permits cannot be obtained, the structure must be removed.
Okay, attached to that letter was some photographs. Can you go through the photographs and tell us what they depict?
Page 222 is a photo of the unfit for occupancy posting. 223, this was also a house that had fire damage. But 223 shows, I believe, what was a sliding door at one point, and the fire damage inside. And more fire damage on 224. And more of the same on 225.
Okay. Was the property brought into compliance as a result of the courtesy code notice?
No.
Did the city issue a notice of code violation on March 19th?
Yes.
Is that reflected in pages 226 through whatever, a number of pages after that in the packet?
Yes.
Okay. Was it the same code sections?
Yes.
Okay. And was it the same photographs that you just went through earlier?
Correct.
All right. And was this notice of code violation sent by certified mail?
Yes.
And did the city receive a response to that letter?
I am not seeing the signed card in the packet.
Okay. Well, did the city follow up with a statement of violation?
Yes.
And that's reflected on page 241?
Correct.
In the packet, it's stating that it's the amended statement of violation. Can you explain the reason that the original one was amended?
Yes, the incorrect parcel ID was on the original statement of violation.
Did the city also issue a notice of hearing for today's hearing?
Yes.
Is that located on page 243 and 44 of the packet?
Yes.
And how did you send that statement of violation and request for hearing? And the
They were
notice of
sent
hearing?
regular mail, certified mail. The property was posted, and The notice was also posted here at City Hall.
And did you issue an amended affidavit of service?
Yes.
And is that located on pages 239 and 240 of the packet?
Yes.
What was the reason that the affidavit of service was amended?
The same. The parcel ID was incorrect in the original.
Okay. So there are a couple of photographs at the very end of the packet. Could you explain what those two photographs depict? Pages 246 and 247?
246 is the notice of hearing that was posted at the property, and 247 is a picture of the notice of hearing posted here at City Hall.
Has the city received any correspondence or communication from the property owner about this case?
None that I'm aware of.
Okay. Is the property still in the same state as it was in the photographs?
Yes.
Okay. Have you, well, can you recommend the number of days that you're asking for the property owner to have to come into compliance?
Same as the other cases before today, the 30 days and $250 a day.
All right, thank you. I have no other questions from Mr. Pinkard. I would tender into evidence the packet documents starting at page 217 and going to page 245 or 246.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 217 through 247 of the agenda packet. Is the owner here, Ms. Shirley McFarlane, or anyone on her behalf here today? Okay. I don't see anyone. All righty. Mr. Trask, any other witnesses you want to call?
No, no other witnesses.
All right. Last call for Ms. McFarlane, the owner of the property, or anybody on behalf of the owner of the property located at 433 Boca Ciega Drive. Okay. How about any members of the public that want to come and comment in regard to this code violation at 433 Boca Ciega Drive? Okay. Still seeing none. All right. We'll close public comment. All right. Based upon the testimony of Mr. Pinkard as well as the record evidence, I'll go ahead and find that the property is in violation. The property owner will have 30 days within which to bring the property into compliance, and thereafter will be a $250 fine per day. All right, Mr. Trask, is there anything else before me today?
No, I think that's it.
I think that's it as well. Thank you all for coming today, and that concludes today's hearings.
Thank you.